Welcome, welcome to Patriots Corner Live with Dr. Hill Law, your source for unfiltered conservative analysis. We're here to dissect this week's biggest stories in politics and the economy, all from a grounded conservative perspective. No spin, just straight talk about what matters to you. We'll delve into the issues shaping our nation and hold our leaders accountable and discuss and debate the solutions that uphold our core American values. Now, if you're new here on the Patriots Corner, please hit that like button, subscribe, and ring the notification bell so you don't miss any future streams. Today, today in a landmark decision that sent ripples through the American legal landscape, the Supreme Court delivered a ruling that significantly curtailed the authority of the federal judiciary, simultaneously bolstering the power of the executive branch. This pivotal judgment, keenly anticipated by legal scholars and political observers alike, specifically addressed the controversial practice of universal injunctions. Justice Amy Coney Barrett, delivering the majority opinion for the court, articulated the core of the ruling with precision and clarity. The injunctions before us today, Justice Barrett stated, reflect a more recent development. District courts asserting the power to prohibit enforcement of a law or policy against anyone. These injunctions, known as universal injunctions, likely exceed the equitable authority that Congress granted to the federal courts. Her words underscore a critical reinterpretation of judicial powers, suggesting that lower courts had overstepped their constitutional bounds by issuing nationwide orders that effectively halted the implementation of federal laws or policies for all citizens, regardless of whether they were directly involved in the lawsuit. This ruling is not just an isolated event, but rather the culmination of a profoundly impactful 2-day period at the Supreme Court. It stands as one of 4 historic opinions handed down as the end of the 2025-year calendar period comes to an end for the summer break, and as it draws to a close, each with far-reaching implications. These decisions, taken collectively, are poised to reshape the relationship between the branches of government and redefine the scope of federal authority. All right, sorry, I was trying to make sure my mic was connected. Right. The relationship between branches of their ramifications are expected to touch upon various aspects of American life, affecting some, if not all, citizens across the United States in profound and unprecedented ways. On today's episodes of Patriots Corner with Dr. Law, I will meticulously dissect these monumental opinions. Give you my analysis. Will delve into the intricate legal arguments presented by the court, exploring the precedent set and the potential legal challenges that may arise. Furthermore, I will provide a comprehensive examination of the political implications inherent in each ruling, assessing how they might influence future policy making, the balance of power in Washington, and the overall trajectory of American society. Join me as we navigate the complexities of these decisions and unravel their potential impact on the fabric of our nation. You can catch Patriots Corner live 3 evenings a week on YouTube, Rumble, Twitch, and Facebook. If you can't catch it live, you can listen to all the episodes. We'll watch them too on Spotify, listen to them on Amazon and iHeart, approximately about an hour or two after I air it live. Or you can catch them on our website at Patriots Corner with drhilllaw.com. Again, that is Patriots Corner with drhilllaw.com. Now, your engagement is crucial to the success of Patriots Corner. If you have a question or want to make a statement, please do so. I review them at the end of each segment, reading a few live and answering questions from respectful comments that foster intellectual debate. Your feedback is invaluable in shaping the discussion. Also, don't forget to like, share, follow, and subscribe to keep the conversation going. Oh, trying to make sure I got all my... I'm trying to make sure I got all this set up correctly and on there. So, all right. All except paste. All right. I was trying to make sure I had my comments up so I can see them. Alrighty. Now, at the end of each section, I will read, like I said, and go through if any comments and not, and then go to the next segment. So, as the Supreme Court's calendar concludes this week, we've witnessed delivery of several landmark opinions. These historic cases span various critical areas, including immigration law, parental rights, religious liberty, and both judicial and executive authority. Over the next hour, I will dedicate a segment to each of these individual cases. My aims are to provide you with the background information on each case, an analysis of the rulings, implications from a legal standpoint, and an explanation on how they will impact American society. Additionally, I will address common misconceptions surrounding the 14th Amendment or often referred to as the birthright citizenship case. I will explain the meaning of the majority opinion moving forward and when we can anticipate the ruling on this subject. In segment 1, we will cover the Riley v. Bondi case, which deals with immigration law. Now, going on to segment 1 with Pam Bondi versus Riley versus Pam Bondi. Now, let's take a look at the majority opinion in Pierre Yassé Nassan Riley v. Pamela Bondi, Attorney General, and Riley v. Bondi, the Department of Homeland Security, sought to remove Pierre Riley, a Jamaican citizen, from the United States under the expedited removal process. Riley had entered the United States on a B-2 tourist visa in 1995, which allowed him to stay for 6 months, but he didn't leave when his time was up. Instead, he stayed and became a member of a far-reaching and well-organized drug trafficking gang and was charged and convicted for crimes. In 2008, for conspiracy to distribute and to possess with intent to distribute more than 1,000 kilograms of marijuana, as well as for possession of a firearm and furtherance of a drug trafficking crime. He was sentenced to 25 years in prison, but was released in January 2021 when he was picked up by DHS. What is he still doing here, you may ask? It's now 2025, and he was supposedly qualified for the expedited removal procedure. While he didn't contest his removal from the United States, Riley did contest being sent back to Jamaica under the Convention Against Torture and Other Cruel, Inhuman, and Degrading Treatment or Punishment, CAT, treaty signed in 1984. Riley claimed that if he were sent back to Jamaica, a wealthy and powerful drug kingpin who had it out for him and had already killed 2 of his family members would also torture him and kill him. The immigration officer did not believe Riley had proved or demonstrated reasonable fear of persecution. An immigration judge disagreed and therefore sent Riley's case to what is called a withholding-only proceeding. That is a proceeding at which the only issue is whether the alien will be sent back to his home country or whether he will not be sent back to his home country. All right. And then DHS appealed the decision to the BIA, which found that Riley's claim was not supported by sufficient objective evidence. When the BIA vacated the IJ's order, it allowed the FARO, which is a removal order, to be enforced. Therefore, the court was left to identify which order concluded that Riley is deportable and commanded his deportation. It is clear that the qualifying order is the FARO issued by DHS on January 26, 2021. The court also decided that the order was also the executive's final determination on the question of removal. Now, the Supreme Court ruled that the 30-day timeline to challenge the removal order starts when the FARO is issued, not a later BIA CAT decision. Additionally, the court ruled that the 30-day deadline constitutes a claims processing rule rather than a jurisdictional one, which is a positive development for non-citizens seeking judicial review, but it does create a strict timeline for challenging the initial removal order. The case was remanded back down to the Fourth Circuit to decide if Riley's petition for review was timely under the new framework, considering that the 30-day rule is a claims processing rule and potentially subject to equitable tolling, leaving this case to shape future immigration appeals involving Convention Against Torture claims. Now, this could also get sent back after the Fourth Circuit, whatever their ruling comes to. It could end up going back to the Supreme Court. So this guy could be in holding for who knows how many more years. Now, as we come to the end of our first segment, I'd like to remind you to please like, comment, follow, or hit the subscribe button so you won't miss future episodes. Also, I will now take any questions and reply to a few comments before starting the next segment. Now, don't forget to check out our website at Patriots Corner with drhilllaw.com. That's Patriots Corner with drhilllaw.com. Also, you can sign up for free access to our weekly blog, receive notifications about our next live show, and hit the subscribe button, which takes you to our locals community. There you can support the show, gain access to extra content, and participate in one-on-one discussions. Before we get into the next segment, to see if check my messages, do not see any. Alrighty, let me get a drink and then we'll go on to number 2. All right, let's get going. Second segment is going to be Muhammad et al. V. Taylor. All right, which is dealing with the parental rights and religious liberty. Now, in 2022 and 2023 school year, the Montgomery County Board of Education in Maryland introduced a variety of LGBTQ inclusive text into the public school curriculum, which included 5 LGBTQ plus inclusive storybooks approved for students in kindergarten through 5th grade, which have storylines focused on sexuality and gender identity. When parents in Montgomery County sought to have their children excused from instruction involving the mentioned storybooks, the school board initially compromised with the parents by notifying them when the storybooks would be taught and permitting such children to be excused from the instruction. Less than a year later, the school board introduced the new books and it rescinded the parental opt out policy. Now, the school board, facing an unprecedented deluge of opt-out requests from concerned parents, publicly justified is what it says, publicly justified its decision by citing the sheer impracticality of accommodating such a high volume without severely disrupting the educational environment, is what the school board claimed. Now, their official statement highlights the logistical nightmare of creating alternative learning spaces or curricula for so many students, claiming it would lead to an unimaginable splintering of classes and an overall decline in instructional quality. One might reasonably assume that a school board confronted with such widespread parental dissent regarding the LGBTQ plus curriculum would interpret this as a clear signal to reconsider or even withdraw the controversial material. I mean, common sense would dictate that if a significant portion of the community, the very taxpayers funding the schools, actively seeks to shield their children from specific content, then the curriculum itself is inherently problematic, or at the very least, ill suited for the public school setting, or at least for kindergarten to 5th graders. I mean, it's ridiculous. Think about it, people. They literally were telling you, we don't want it. However, in a stark display of personal ideology, this particular leftist leaning school board prioritized the propagation of its specific agenda over the educational well being and parental autonomy of its constituents. Their actions suggest a disturbing indifference to the legitimate concerns of families instead of choosing to press forward with a curriculum that critics argue is less about comprehensive education and more about the semantic indoctrination of an impressionable young minds into a particular worldview. This perceived disregard for parental input, combined with a perceived zealous commitment to an ideological agenda, has further fueled accusations that the board is more interested in social engineering than in fulfilling its primary duty of providing a neutral and academically robust learning environment. I mean, this isn't just happening in Maryland. This is happening in the schools all over the United States. This is getting ridiculous, but that's where this case is going to become such a major, have so much ramifications throughout all of our school systems and for all of us parents out there in the coming future. Because also the funny thing is a lot of people go, oh, it's a bunch of white Christians. No, actually, Montgomery County is Maryland's most populous county, according to a recent survey, and it is also the most religiously diverse county in the United States. I mean, they have the largest makeup of Jews, Christians, Muslims, and Buddhists in the United States. So it's not like the request was coming from predominantly white Christians. In reality, we're coming from parents from all racial and religious backgrounds. In response to the school's board's defiance, a group of individual parents and an unincorporated association of interested parents filed a suit against Montgomery County School District in the United States District Court for the District of Maryland. Now, of course, District Court of Maryland ruled against the parents. Dang it, my phone's decided it wants to talk. Sorry about that, guys. My phone just started kicking on. But, I mean, the petitioners asserted that the board's no opt-out policy infringed on parents' rights to the free exercise of their religion. They relied heavily on Wisconsin v. Yonder 406 U.S. 205, in which the court recognized that parents have a right to direct the religious upbringing of their children, and that this right cannot be infringed by laws that pose a very real threat of undermining the religious beliefs and practices that parents wish to instill in their children. So, no, leftist judges, this is not does not destroy public schooling. It has been ruled on that this is and it's part of public schooling, that even though it's public schooling, parents still have rights. The parents requested that a preliminary and permanent injunction be issued prohibiting the school board from forcing their children and other students over the objection of their parents to read, listen to, or discuss the storybook. Of course, the liberal Maryland District Court denied relief, and a divided panel of the Fourth Circuit affirmed the Maryland District Court's ruling. Then the parents, they appealed it to the Supreme Court, which granted them a writ of certiorari to hear the case. And that puts us at where we're at today. Now, Justice Samuel Alito delivered the majority opinion for the court, siding with the plaintiffs. In Justice Alito's opinion, he stated, "Today we hold that the parents have shown that they are entitled to a preliminary injunction. A government burdens the religious exercise of parents when it requires them to submit their children to instruction that poses a very real threat of undermining the religious beliefs and practices that the parents wish to instill. Wisconsin v. Yonder, and a government cannot condition the benefit of free public education on parents' acceptance of such instruction. Based on these principles, we conclude that the parents are likely to succeed in their challenge to the board's policies." They also said, one of the other justices, concurring with the majority opinion, also said that it's not fair that parents would have to go spend all this extra money to send their kids to private school just so their kids aren't taught stuff that doesn't align with their beliefs. So, as you can say, please don't forget to like, follow, subscribe, and hit that like button. Trying to see if I have any comments right now, but for right now, I really don't see any. So I'm going to take a break here, pause for a minute, and get started on section 3 here in a second. Which will be the Medina Director, South Carolina Department of Health and Human Services v. Planned Parenthood, South Atlantic et al., which is the case dealing with taxpayer funds to fund abortions or through Medicaid. This here will have a nationwide reach too, because now every state in the United States can issue a ruling to stop Medicaid from being used at Planned Parenthood. Because while, yes, Planned Parenthood supposedly offers women's gynecological exams, one thing they fail to tell you is that 98% of their stuff is abortions. The largest amount of their money goes to abortions, even if they classify it under insurance as women's care. Doesn't mean it's truly women's care. All right, so let's get started on section 3. Now, in Medina v. Planned Parenthood, South Atlantic, Planned Parenthood and a patient sued the state of South Carolina for making a law that did not allow for any Medicaid funds to be used for or to opt out or a provider that also provides abortion services. In this case, the plaintiff argued that the state of South Carolina violated the any qualified provider provision in 1396A 23A, which requires the states to ensure that any individual eligible for medical assistance may obtain it from any provider qualified to perform the service who undertakes to provide it. Now, the provision does not define qualified, leaving it to the state's traditional authority over health and safety matters. So, in short, this case was not only about taxpayer-funded abortions, but it was also about states' rights. In July 2018, South Carolina, citing state law prohibiting public funds for abortion, determined Planned Parenthood could no longer participate in the state's Medicaid program. While at the same time, the state also took steps to ensure that other providers would continue offering necessary medical care and family planning services, taking the place of Planned Parenthood services. The plaintiff who joined Planned Parenthood, Julie Edwards, claimed that the exclusion of Planned Parenthood violated the any qualified provider provisions. She claimed that she preferred Planned Parenthood for gynecological care, but couldn't afford it without Medicaid coverage. I don't know very many people that prefer them over whatever else. I mean, now, while the district court granted summary judgment in favor of the plaintiffs and the Fourth Circuit Court of Appeals affirmed, South Carolina appealed to the Supreme Court, which granted certiorari. which vacated and remanded it back down to the Fourth Circuit in light of Health and Hospital Corporation of Marion County, addressing whether another spending power statute created in 1983 enforceable rights. On remand, the Fourth Circuit reaffirmed. Once again, the state of South Carolina appealed to the Supreme Court, which granted certiorari again. Then, in a final 6-3 decision this week, the Supreme Court reversed the lower court's ruling, stating that any qualified provider in the Medicaid Act does not clearly and unambiguously confer individual rights enforceable under 42 U.S.C. 1983, strengthening previous court precedent that establishes a stringent and demanding test for determining when a federal spending clause statute creates a privately enforceable right under the 1983 statute. For such a right to exist, Congress must have used right-creating terms with an unmistakable focus on individuals. Meaning, if they did not put it in there by the words in the bill, it is not considered. Now, as we come to the end of our third segment, I would like to remind you to please like, comment, follow, or hit the subscribe button so you won't miss future episodes. Also, I will now take any questions, reply to a few comments before starting the next segment. Don't forget to check out Patriots Corner with drhilllaw.com. Again, that is Patriots Corner with drhilllaw.com. And let me know if anybody's I'm trying to see Friday night. Maybe this isn't the best night to do lives, but I was trying to, there we get, that's what, maybe this will help here. Maybe if I get some more of these in here, I will get, nothing was in Tennessee today. It's funny how it's bringing up stuff that has nothing to do with today's decision in these, but trying to make sure taking my little break, trying to make sure I had everything I needed on my YouTube to keep it going. Okay, it says I have 4 on Rumble. All right, guys, I'll get going. Sorry, I didn't notice I had 4 people on Rumble there. Let me get back going. So I will get started on our fourth and final section, which is going to be really the one everything we've been waiting for tonight, and the most talked about and largest decision that was made this week, and that is the Trump v. Casa nationwide injunction case. So now for our fourth and final case, the one, like I said, everyone's probably been waiting for, we delve into the intricate details of President Trump of the President Trump, President of the United States et al. V. Casa. This landmark case brought before the Supreme Court addresses critical issues that have significantly shaped the legal and political landscape of the United States. At the heart of Trump v. Casa lies a concerted effort by various Democratic organizations and individuals, these entities engaged in judge shopping as a strategic mover to bring their constitutional challenges before liberal judges who were more likely to reach their intended outcome in issuing the nationwide injunctions. Their primary objectives was to contest the constitutionality of President Trump's executive order concerning the interpretation of the 14th Amendment. Specifically, the executive order posed an interpretation that the 14th Amendment has never, in its historical application, conferred birthright citizenship upon individuals who merely enter the United States and give birth within its territorial borders. This interpretation directly challenged longstanding legal precedents and societal understandings of birthright citizenship, igniting intense debate across the nation. Now, a common question arising from this case was why the Trump administration did not ask the Supreme Court to definitely rule on the constitutionality of the 14th Amendment itself, choosing instead to focus solely on the ability of the federal judges to issue nationwide injunctions. Now, only President Trump's legal team truly knows the strategy behind their actions, but I'll try and take a stab at the reasoning behind such a move. From their perspective, nationwide injunctions coupled with politically motivated liberal judge shopping had become a pervasive tool used to obstruct and attack a wide array of President Trump's policy agenda items. This pattern of legal challenges created a significant impediment to the executive branch's ability to implement its policies effectively. Furthermore, the existence of a nationwide injunction in this specific case created substantial practical difficulties. With such an injunction in place, the federal agencies responsible for drafting and implementing the policy changes outlined in the executive order were effectively paralyzed. They were unable to commence the crucial work of developing the detailed regulations and procedures necessary to put the policy into action, which then this large of a policy change would still have to be voted on in front of Congress and the House. It had to be approved in both houses of Congress, and the House and the Senate. So this explains a critical moment during the justices questioning Trump's legal team. The team lacked concrete answers regarding how the policy would be practically implemented or how it would specifically affect individuals in various situations. This lack of detailed implementation plans was a direct consequence of the nationwide injunction, which prevented the necessary preparatory work from taking place, thereby limiting the government's ability to articulate the precise operational impacts of the executive order, which is one of the reasons why I believe they decided not to move forward with the case in general overall for the constitutionality of it, is because they can't even move forward with trying to put together, having the individual agencies put the policy together that would actually then be presented as a policy change, which shows that President Trump is not defying the Supreme Court. He is following the Supreme Court's orders. He's not going outside their orders. He's doing what he's supposed to. Now, the case, therefore, became a pivotal moment for clarifying the scope and limitations of judicial power in issuing nationwide injunctions, especially when they directly impede the executive branch's ability to execute its policy agenda. So now let's get into how the majority opinion was reached and the implications that it has on the 40 some odd other executive orders that have been slapped with nationwide injunctions, and how the power was given to the executive branch by our founding fathers is restored, and the judiciary was never meant to be more powerful than the executive. Now, the case started with plaintiffs and states filing 3 separate suits to enjoin the implementation and enforcement of President Trump's executive order number 14160. In each case, the district court entered a universal injunction, an injunction barring executive officials from applying to the executive order to anyone, not just the plaintiffs. In each case, the Court of Appeals denied the government's request to stay the sweeping relief. Now, the executive order argued that in circumstances in which a person born in the United States is not subject to the jurisdiction thereof and is thus not recognized as an American citizen, it sets forth the policy of the United States to no longer issue or accept documentation of citizenship in those 2 scenarios. Those 2 being when a person's mother was unlawfully present in the United States and that person's father was not a United States citizen or lawful permanent resident at the time of said person's birth, or 2, when a person's mother presence in the United States was lawful but temporary, and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth, as stated majority. That's not majority opinion, messed up, but that was as they were stating, they stated in the majority opinion, but that's just a reading from the executive order. I was trying to once I started reading that, I noticed how confusing that statement could have been. So I was trying to clarify that. It was stated in the majority opinion. That's where I cited it from, but it's also directly from the executive order. Now, President Trump's administration filed 3 nearly identical applications seeking to partially stay the universal preliminary injunctions and limit them to the parties in the respective suits. This is why the Supreme Court did not address the question of whether the executive order violates the Citizenship Clause or the Nationality Act as per the majority opinion, because they did not. That's not what the president's team was charging. They were requesting for a partial stay so that the orders are only affecting people who are enjoined in the case, not the whole of America. Now, the Supreme Court has been asked multiple times across multiple administrations to decide the proprietary of universal injunctions. One argument for universal injunctions to be justified is that they are an exercise of equitable authority, yet Congress has granted federal courts no such power. In the majority opinion, the justices look back to our founding to find the authority of universal injunctions in even English common law, and they don't. All right. As Justice Barrett stated on the question, the answer is no, neither the universal injunction nor any analogous form of relief was available in the High Court of Chancery in England at the time of the founding, equity offered a mechanism for the crown to secure justice where it would not be secured by the ordinary and existence processes of law. Nor did the founding era courts of equity in the United States chart a different course. As Justice Barrett clarifies, but to allow all persons subject to the statute to be treated as parties to a lawsuit would confound the established order of judicial proceedings. According to all historical documents that even the justices could find, universal injunctions were not a feature of federal court litigation until sometime in the 20th century. Yet they remained rare until the 21st century. As a quote from Professor Sohami, had federal courts believed themselves to possess the tool, surely they would not have let it lay idle. Meaning, if this had been a tool they'd had all along, why did nobody use it in the 18th or 19th century? Why was it not even used sparingly until the 20th? Why was it not used during the New Deal era? When that was literally the New Deal era was as many executive orders as you see now, and actually more confounding executive orders, because Social Security and Medicaid and almost all of our social services were implemented through an executive order. Obviously, they were later codified by legislation, but they were started by an executive order. Why wouldn't they use this then if it was there? Now, which led the majority of the justices come to the decision, because the universal injunction lacks a historical pedigree, it falls outside the bounds of a federal court's equitable authority under Judiciary Act. Blah. So pretty much what they're saying is they could not find any evidence of the authority of universal injunctions to be given to a federal judge anywhere in history. They couldn't even find them being used till the 21st century. And actually, if you look at like the 18th century to the 21st century, before President Trump's term this time, there was only 168 injunctions, period. President Trump, between his first term and this term, has had almost 148 nationwide injunctions enjoined on him. So now, obviously, everybody who's saying, oh, we hate this, that's what's kind of funny to me, is dissenting justices that you saw today on the liberal side were literally asking for this same thing to be ordered on during Biden's 4 years. Even though Biden only suffered 27 or 28 nationwide injunctions, or universal injunctions as they're called legal wise, all the liberal justices were asking for this same thing to be heard during Biden's. But now that all of a sudden it's Trump's, only one wants to vote with us and the rest want to dissent, when they know the same thing is going to be effective. Now, this doesn't mean Trump can just go do whatever, right? Doesn't mean he can be a king. All this means is that while the challenges to the executive order, policy, or legislation are going through the court system, that it can still be put into effect for anybody who is not enjoined in the case. So no, what Jessica Tarloff said on the 5 today about, oh, they can still get it through they can go through what class action? Not unless they join the class action. Would the class action work? Because pretty much this was a class action. It was 3 different states, all different groups, three different courts. Unless they go to every court, even if they went to every district court in the United States, unless everybody that it affects signs on to it, whoever doesn't sign on to it, it has no effect on them. So the law still can be, and then obviously once it gets through the judiciary, gets up to it, if it gets to the Supreme Court before the end of the one term, then it's heard at the Supreme Court level. And then if the Supreme Court rules it's constitutional, then that usually gets codified through, well, this would be one of those instances where it actually it's such a large policy change, it would have to be approved by both the House and the Senate. So that's almost like a codification in its own right. Even though it's not officially a piece of legislation, it still codifies it to a point. Then if the Supreme Court rules it as constitutional new authority, then that has precedent. So that kind of sticks it there. Now, for some reason, it was drawn out, didn't make it till the Supreme Court till, let's say, after, because there was a couple executive orders and stuff that had made it, were going through the legal challenges under Biden coming to the end of president at the end of his term that were still in the courts now. And of course, they've all been dropped by the Justice Department because President Trump is moved them, has counteracted them. And for instance, there was a big, huge green energy policy change that the EPA President Biden had put in effect, and it didn't make it through all the way till towards the end. And then because it was such a large policy change, trying to think the exact level that it actually has to go through the judicial review and makes it to the approval from Congress and the Senate. Can't think of the exact triggering level for it. But of course, the House and the Senate voted it down, said, no, we don't want to approve this. So there's still a possibility that it could get voted down that way, because something this major of a change just can't be put in if you're not changing the whole policy, you're just changing bits or pieces of a policy of a certain division that you don't need an ALJ for, that you don't need to get approved by both houses of Congress. But if you're literally rewriting a whole new policy or rewriting the whole policy, that triggers it to have to be approved by both houses. So it could still get stopped that way. But it doesn't mean he can be a king and do whatever he wants. He still has to go through the court system. It still goes through the courts, and it still gets ruled on by the justices. But what this means is that while it's going through the court systems, he can at least do the studies that are required. They can get the studies, the agencies or executive agencies that are in charge of that specific executive order or whatever policy that executive order affects, can do whatever studies are needed to be required to decide how that policy is going to be structured and written. They can go ahead and get the policy written and structured. So that way, when the case does make it to the Supreme Court, after it goes through the federal district court, the appellate court makes it the Supreme Court to be heard, unless obviously the Supreme Court decides to hear it on the emergency court docket and skip the federal appellate court, which, see, this thing didn't even really skip the appellate court. All it did was give them a temporary partial stay until it makes it through the court. So this didn't legalize make birthright citizenship illegal, do away with it. This didn't say that it was constitutional. This didn't order it was unconstitutional. All this ordered was to say that they can't issue nationwide injunctions. If they want to issue an injunction, it can only enjoin the government from enforcing that law or that policy or that rule on the people who are a party to that case. If you are not a party to that case, then it doesn't affect you, period. That's it. You're not affected by it. You can still be ruled under it. That's what today was. Now, while Pam Bondi said, oh, they could still roll on it now, I don't think I said this back whenever they were doing they were televising the hearing for this case. Based on the questions I was hearing, then a case or two that came after it, I said, I know that they're going to rule in favor of universal injunctions being not allowed or being too much power. But I said, I don't think they are satisfied with the answers they are getting on the birthright citizenship yet to finalize the case. So they're not going to rule on both. Even technically they could have, even though this case even though they were only requesting for the review of the universal and the partial stays, the Supreme Court could have ruled on the other part. But obviously Trump's team did not have enough answers for, well, what if this situation happens? How would it affect them? They couldn't answer that because they couldn't move forward with creating the policy. So I think it's going to be more like October, maybe March next year, before the case gets heard, because Trump's team is going to need time to put that policy together so then they can correctly answer the questions and have the answers that the justices are going to want before they make the decision. Now, obviously, if it does get ruled that the interpretation of the Constitution has been read wrong and that it was never meant to include illegal immigrants, when originally it literally was said that that the whole point of the 14th Amendment was to overturn Dred B. Scott to ensure that children of former slaves were U.S. citizens. That's why it was created. It was not, at the time it was drafted and it was ratified, it was not thought of to cover just any person that comes into the country. So obviously nobody's ever challenged it, and we've had mainly liberal leaning courts anyways, so it would have always been ruled as constitutional. But now that we have a more originalist, conservative leaning court, I don't necessarily, I see it being a 5-4. It's going to be split down the party lines. It'll be all the Republicans, the 5 Republicans against the 4 Democrats dissenting if it gets ruled that the reading President Trump's executive order is constitutional and the interpretational reading of that is constitutional. And they reverse the president like past president, just like they did with Chevron deference. So we'll see what happens. Obviously, it's going to be a big case to watch for. Those were the main 4 cases I covered. There was also the recent case here in like a week or so ago, the Tennessee law that outlawed transgender treatments or surgeries for children, that ruled it as being constitutional to outlaw those. And then also there was one other case that the law in Texas that requires you to show proof of being 18 or older to access pornographic material online, that was not a First Amendment violation, that it was drafted, it was aimed specific enough at a specific instance that it was not considered a First Amendment violation. It was tailored specific enough that they believed it was in line with what other states had, and it was within line of protecting children from possible unseemly materials. There was another court case that came out, but it really doesn't have much to do with nationwide, like on a national scale. I mean, it still obviously affects nationwide, but it had more to do with a criminal law than anything. So it's not something that can affect everybody, but these are the ones I thought would be the most important to cover, because obviously everybody knows about the 14th Amendment one, and the nationwide injunctions is a big monumental, will have ramifications throughout this administration and future administrations. It will actually require Congress to hopefully start working together and get back to having to work so the presidents aren't doing everything through executive order. I mean, the reason why they do everything through executive order, because if you had to wait for Congress to do anything, nothing would ever get done in 4 years. So that's why I picked those 4. Obviously, the big one was, I think, and definitely for me, because I've got a 13-year-old, a 12-year-old, and soon to be 3-year-old. Luckily, I live in Texas, so we don't usually have dealing problems with this. But if it was that problem, I know that now, constitutionally, if the school tries to start bringing in transgender LGBTQ teachings in kindergarten, I can say, oh, you're not teaching that to my child, and there's nothing they can do or stop it, because that case being decided for, even though it was in a Maryland school, that will now be considered, now all schools will have to account for that, because it's not going to change in any state you go to. Oh, yeah. It needed to happen 3 decades ago. I know, and that's why I said a minute ago, I thought it was funny that people were arguing, like you saw the liberal justices dissenting, but this has been mentioned. I mean, the justices when Obama was in office were saying that they need to rule on this, that they needed to hear this. They were asked to rule it during the first Bush administration, Obama's administration, Trump's first administration, Biden's administration. It finally got taken on, but the problem is I think it's been more because it's a political thing. Whenever the other party's in power, of course, you don't want it ruled on, because you know it gives that party more power. But yeah, it's insane that, I mean, like, I don't know how long you've been on here, but like I was reading a minute ago, it's just common sense. It's crazy that they wanted that. Literally, those justices explain to me how the Constitution meant to give one district court judge the right to affect the whole United States when there's almost 1,000 district court judges. It makes no logical sense. Now, obviously, the Supreme Court has that right. It's the Supreme Court, the law of the land. But if you actually go back, like people try to say, 3 co-equal branches. If you actually go back and read the Federalist Papers, I think it's Federalist 10 or Federalist 42, one of the two, Madison actually states that no, the judicial branch was not meant to be a co-equal branch or a greater branch. It was meant to be the lesser branch. It was meant to, exactly what they said. It was not to be a co-equal. It was meant to be a lesser branch of government. So the judicial is not supposed to have that much authority. Now we can say also this will now help save our government millions and millions of dollars, especially the White House, and not having to fight cases. I mean, obviously they'll have to fight them on an individual basis or whatever, because obviously they're still going to contest that legislation or that executive order, but now it can't be affected nationwide. Now it only affects the people who are enjoined in the case. So, I mean, yeah, if you create a class action lawsuit and you get 100,000 people to join it, those 100,000 people cannot be affected by that executive order or that piece of legislation, but it still doesn't go to 300 million. So what Jessica Tarlow on the 5 said doesn't make sense, because even if you went under that type of case, it still wouldn't include everybody. So, but I guess if we don't have any more comments or replies, that's kind of about everything. Just come to the end. Just please don't forget to hit that like, comment, follow button, subscribe. Just getting started doing this. Only been doing it about 2-3 months. So more likes and comments and follows I get, the more pushes it out on Rumble and YouTube. Use all the help I can get to get it out there. Obviously, if I get where I started doing this full time and have a whole lot more, also, you got any tips? I tried to get the light down today where it wasn't as shiny on my head. I think it looks better, but I am not to the point where I'm willing to put makeup on yet. Now, that's the only reason why their heads don't look shiny on the news channels, is because they're wearing base. But and I finished a little faster than I thought I would. Thought it might take an hour, but only took about 45 minutes. So thank you for watching today. Appreciate it. At least got a little interaction today. Really interacting, messaging. That's what will make this show better, because if I'm not explaining something, especially when I'm doing legal stuff like this, if I'm not getting it across clear, please let me know and I will try to break it down a little more, because I tried to shorten it down as much as I could without getting all the legal easy of it, and trying to break it down into a simple explanation. But that gets a little bit of hard sometimes especially when you're trying to give the background, because I mean, each one of these opinions were anywhere from 30 to 50 pages. And that's the syllabus, which gives you the background on the case, and then the opinion of the case with your dissenting opinions. Well, actually, with your dissenting opinions. That wasn't even the actual underlying dockets and writs and everything that are involved with the case. That was just literally the syllabus and the opinion, which then they give you a look at what underlying previous Supreme Court cases or legal precedent they use to reach their decision. So everybody have a good night. I appreciate it. Looks like I had at least a decent night of people on here, and I will see y'all. Will be probably Monday this week. After this week, it will be Sundays, Wednesdays, and Fridays for at least the next month. And then once my classes start back fully up, I'll have to see. That's why I say go to my website at patriotscorner with drhilllaw.com. And that's just Patriots Corner with drhilllaw.com all together. No dividing it. Go on there. You can hit the sign up button for free. It just gives me your email so I can send you an email out if I change the date or time, or exactly what time I'm going to get in on that day, because I still work a full-time job. So I have to get home, get everything get the rest of my content put together, get it put into the system, everything like that. So sometimes it's a little later than other days. So thank you for watching, and y'all have a good night.